I'm head of European policy at FTA and in charge of FTA's Brussels office, and I'm going to take you through this edition of the webinar. So in terms of what we're going to cover today, I'm going to focus first on the status of negotiations, give you a bit of an update there, explain a little bit what happened in December, what the implications are for companies, and give you a bit of a view on the latest developments with a specific focus on what has been happening in Brussels. Then I will talk you through the next steps and what to expect in 2018, especially in the first quarter. I will then take you through some slides on how you can actually prepare for Brexit, both in terms of your company processes, talking to your suppliers, customers and so on, but also in terms of representation, how you can remain informed and so on. And then I will briefly outline some forthcoming FTA events and activities for the first part of the year. Okay, so before we actually start with the content, I just wanted to remind you of some important house rules. Please keep your microphone and telephone muted. The webinar is going to be recorded, so obviously you'll be able to access a full recording afterwards on the FTA website. If you are familiar with the webinars, you will see that all previous editions are already available, so that should be the case within a couple of days. Unfortunately, we are not going to be able to deal with technical issues during the webinar, but obviously, if you do experience issues, you can go back to the recording at any time later on once it becomes available on the FTA website. The last house rule to mention is that you can use the chat box to ask any questions you have throughout the webinar, and if there is a bit of time at the end, I'll try and answer them. If not, the device is going to record the questions, so we'll come back to you in any case. Okay, so in terms of the current status of negotiations and where we are, so to sort of summarize before we dive in the details a bit more, basically on the 15th of December last year at the EU Council meeting with the heads of state and government of the 27 remaining countries, there was a decision to state that sufficient progress had been made on withdrawal issues, the financial contribution, citizens' rights, and the Irish border status, and therefore the talks could proceed to phase 2, namely the transition and the future relationship. So as a first step, a green light has been given on exploratory talks on the future relationship. That means that while the door was very much closed for civil servants, UK civil servants who wanted to talk to their counterparts about anything to do with the future relationship. Now there should be a bit more flexibility. The talks will start with transition. So at the moment, most of the work and discussions is taking place within the EU27 group, to be honest, and they are going through various seminars and presentations by the task force of Michel Barnier on several aspects of the transition, but also the future relationship. And in parallel, they are also reviewing a set of guidelines that were produced on the 20th of December last year by the task force of Michel Barnier that state the EU27 position with regard to the transition. So I will tell you more about that in a few minutes. In terms of the future relationship itself, we are hoping that formal talks could start in spring. That would require the EU27 to approve a new set of guidelines, which is not going to be the case before March 2018 in any case. But hopefully there could then be some discussions going on as of April or May. Obviously, with all of this, I think it's fair to say that the prospect of a no deal very much remains on the table. It's unfortunately not something that we can discard, and it's certainly not something that the UK government is disregarding, or indeed the EU side. because the EU side is also busy preparing contingency plans, as you will see for aviation in a few minutes. So yes, in a nutshell, that's where we are. The idea is that the Council is going to adopt guidelines on the transition period at the end of January, and then the formal negotiations with the UK government on the transition will start. Hopefully they will be closed when the discussions on the future relationship start, but it could be that these two have to run in parallel. Before I talk about the future, perhaps looking at the past and what has been agreed in December, a point on EU citizens' rights. I think what was agreed or wasn't agreed might sometimes have been slightly misrepresented in the press, and we've received quite a few questions on this. So I just wanted to clarify what had been agreed, what the status of the agreement was, and basically how credible and tangible this is, and how legally binding it is for you, so that you know what to expect in the future. So as you will have understood, I guess by reading the press, indeed, as David Davis said, the joint agreement is not legally binding. However, I'd like to make an important distinction. It is politically binding. So it's politically binding on both the EU and the UK government. Obviously, that requires a deal. If there is no withdrawal agreement in the end, if the two sides decide that they cannot agree and there is a no deal scenario, there will not be a legally binding document or agreement. So this is the caveat I'd like to put on this. However, the intention is very much for it to become legally binding, and both Theresa May as well as Michel Barnier and of course the EU Council, so all the heads of state and government of the remaining member states have given their political word that this is something that they intend to very much translate into binding agreement. So I think from a workable perspective, from an industry perspective, if you look at it as something which is highly likely to be in force post-Brexit, with the exception of a no-deal scenario, where obviously we're not sure if that would apply or not, you can then see how useful it's going to be in practice. So in terms of what the agreement covers, basically it tackles the situation of EU citizens that are resident in the UK at the point of Brexit, or until the end of the transition period. That's something that has not been agreed yet by the two sides, but the EU side has very much said that they'd like EU citizens to retain freedom of movement throughout the transition. So that covers not just people who have jobs already, but also students. So any EU nationals who are studying at the moment and might be looking for jobs in the future, any apprentices, any job seekers as well, who are looking for a job in the UK at the point of Brexit, will be able to stay. For the job seekers, they'll have a period of 6 months, which is equivalent to what exists today. And if they don't find any jobs within 6 months, of course, the UK government will have the right to ask them to leave. But anyone who is a legal resident at the point of Brexit and might be employed legally in the UK will have the right to stay. This is a very important point to make. So it means that all the drivers and warehouse operatives and other logistics workers who are currently working in the UK and are resident in the UK will be able to keep their jobs and keep on living in the UK, assuming, of course, there is a deal. The same goes for frontier workers. So, for instance, citizens that would live in France or Ireland and work in the UK will be able to keep working in the UK post-Brexit. And the same goes for close family members of legal residents, whether or not they are in the UK pre-Brexit. So, for instance, someone who's married to an EU citizen who lives in the UK pre-Brexit will be able to come to the UK and look for a job much in the same way as a UK citizen post-Brexit. Same goes for children. Obviously not for loser family relationships, so not nephews or cousins, for instance, wouldn't be covered. What the agreement means is that all their rights will be protected, including the right to be employed in the UK, and discrimination against them will be illegal. So they will have the same rights, basically, that they have today from that point of view. EU citizens will have to make an application to UK authorities to validate their status. This is, however, primarily an administrative process, so it's not something that changes their rights in any way. It's just a formality they have to go through. After 5 years of legal residence in the UK, they will be granted permanent residence rights. So, for instance, an EU citizen with a permanent residence document will only need to present an ID, declare any criminal convictions, and demonstrate continuous residence in the UK, and they will automatically get their status clarified. And the procedure will be free. So this was a very important point, obviously, for the EU27. The workers who are not permanent residents will not be covered by the joint agreement. This is something worth mentioning. So, for instance, if you employ any agency drivers who might only work in the UK for 2 or 3 months per year on a routine basis, it doesn't really matter if they come back every year. If they are just there for 2 or 3 months per year, they wouldn't be covered by this agreement. More generally, an absence of less than 6 months is tolerated to be considered a resident. So basically, any EU citizen who lives at least 6 months and 1 day per year in the UK is considered a resident and is covered by the agreement. Once a citizen has a permanent right to stay in the UK, only an absence of more than 5 years can affect their rights. So someone who has had permanent resident status and then didn't take the citizenship and decides to leave the UK to go back to their country, for instance, if they go for more than 5 years, or because you want to promote them to another role outside of the UK or whatever, they can move. But if they move for more than 5 years away from the UK, they lose their rights. So obviously then their situation would no longer be covered by this agreement and would very much depend on the future immigration policy of the UK. There are, however, a number of pending points. So what happens during the transition? As I said, the EU side very much wants all of these rights to continue during the transition period, but this is not necessarily a given. It will take negotiation with the UK government. We have no reason to expect they will say no at this point, but obviously we cannot say until the negotiations have really started on this point. What happens in case of no deal is also not a certainty. Although the two sides have said that they feel politically bound by the agreement, there is no certainty in legal terms that the agreement applies in case of no deal. So this is obviously a big question, a big if. And the recognition of qualifications post-Brexit is also something which is not fully clarified at this point, and which will be discussed in the second phase of negotiations. But with these caveats, at least you know that if there is an agreement, all of these provisions are going to enter into force. And there's very, very little likelihood of it being changed. The biggest risk really is a no-deal scenario. So in terms of where we are more generally in the negotiations, so the withdrawal arrangements, which are the most pressing matters for an orderly withdrawal, so citizens' rights, financial settlements, Ireland primarily, this is still ongoing. So although certainly for citizens and financial settlement, I would say that the issues are pretty much closed. So they've reached an agreement. So it's not going to change in the future. For Ireland, for instance, they only reached a fairly high-level political agreement. So there will be a lot of work that's going to continue on Ireland, and which is already continuing, in fact, as we speak. And all of these issues, as well as issues that have not been discussed yet, and I'll come back to that in a moment, that would be part of this first phase of negotiations, are going to be worked on a bit more, refined, and turned into a legally binding agreement. In parallel, obviously, work is progressing on transitional measures. These will be limited in time, and the negotiations on this could start in February. The intention is for the EU27 side to adopt a set of guidelines setting out how they see the transition period at the end of January. So that would then allow actual negotiations on the transition to start hopefully in February. And then, of course, you still have two pretty important phases, which are the phase on the framework for the future UK-EU relationship, the preparatory discussions, that will start later and will require the approval of a new set of guidelines, not before March in principle. And then, of course, post-Brexit, but potentially during the transition period, the negotiation of a comprehensive free trade agreement with the EU. And we understand that, for instance, provisions for road transport, aviation, and similar matters could be discussed at that point, assuming, of course, that things go according to plan and that there is both an agreement in terms of the withdrawal topics and the transition period, which is agreed by the European Parliament, the UK Parliament, the UK government, and the EU27. So I wanted to update you on the latest developments from the EU27 side. As I said, they have already started working a lot on the contingency with a focus on some specific topics. Preparedness of industry is also high on their agenda. It's debatable whether these notes are really helping in this respect, but at least the Commission has produced a series of notes to industry on the impact of no deal. You have to really understand these notes in this context. So they are not there to necessarily make recommendations to industry as to practically what can you do, what should you do. These notes are not there either to really tell you what agreements would replace the existing arrangements, or if there are international agreements that really cover it. Sometimes some of these existing international agreements are referred to, but not in a lot of details. So these notes are really there to tell you, from an EU point of view, here's what happens to legislation which is currently applicable in the UK. Here's what happens in terms of all the rights and procedures that exist today. Basically, all of this ceased to exist at the point of Brexit, and it explains in more details exactly how these provisions cease to apply. But as I say, it doesn't say anything about a potential transition, and it doesn't say anything about replacement solutions for the future. So the Commission has published a number of these notes, including one on aviation, one on road transport, as well as several ones for various sectors, from pharmaceuticals or chemicals, for instance, to food products. So these notes are useful and interesting, but if you find them, don't read too much into it either, because it's just a very clinical view of what happens in terms of the EU arrangements. But it doesn't mean that there will not be a transition, and it doesn't mean that there will not be new arrangements to replace the existing ones. The EU27 side, as I said, has also started to discuss what the future relationship should look like. They've had a series of seminars, and one of the latest ones, which happened 2 days ago, was in fact on aviation. So it was just an internal EU27 seminar, so there were no representatives from the UK government there, and it was certainly not part of negotiations. It was just part of the preparation phase, so that the EU27 side could come up with one negotiating position on aviation once the negotiations on this really start. The Task Force 50 of Michel Barnier made some slides available afterwards, and these slides are readily available. They are public, and they cover various options for aviation during a possible transitional period. They also look at options for the future, which means post-Brexit and post-transition, and they also look at potential contingency measures in the event of a no-deal scenario. So I would say that these slides were perhaps even more interesting and useful than the notes, in the sense that they actually look at solutions and not just purely what happens to the existing arrangements. So they start by presenting the default situation, explaining that the UK will cease to be part of the fully liberalized EU aviation market, and will basically lose access to the existing rights, obligations, and benefits that are granted by EU membership. So, for instance, there will not be any traffic rights. It's the end of market access, potentially, and third country restrictions might kick in. It also says that there would be the end of mutual recognition of certificates and approvals, and the end of participation in the Aviation Safety Agency, in the European Aviation Safety Agency. Under this default situation, it states that indeed there is no WTO fallback, but however, reassuringly, that the EU has extensive practical experience in negotiating international agreements with third countries in the field of aviation. So the slides then go into what happens during the transition, and basically claim that under a transition, the status quo for aviation would be very much maintained. So this is important and reassuring, I would say, for shippers, for instance, who rely on aviation to transport their products. It's also reassuring for operators as well as logistics companies that make use of aviation for the transportation of goods. And hopefully there will be some lessons learned as well for other modes of transport, although this is not confirmed. So what does the status quo under a transition period means? Basically, full market access retained, including cabotage. The UK would be considered pretty much the same as an EU member state from an ownership and control perspective. There would be harmonized standards in safety, in security, in air traffic management, consumer protection, and the mutual recognition of certificates would be guaranteed. So this is, pretty reassuring from that point of view. Obviously, the UK would remain bound by EU aviation agreements with third countries, but would no longer be represented in governance structures for these agreements, and would have to respect the level playing field, for instance, in terms of state aid control. The slides then go into the different options for the future relationship, arguing that the most likely option is that the EU and the UK would have to negotiate an air transport agreement and an aviation safety agreement. So this is for the post-transition period. And that these agreements would have to cover market access liberalization, coupled with the regulatory cooperation and convergence. They envisage that the various parties would keep their own respective regulatory frameworks, and that there would be an arbitration mechanism in case of disputes through a joint committee. Obviously, this market access agreement would be complemented by additional, more specific agreements, for instance, on safety, when appropriate and mutually agreed. In terms of the future safety relationship, not to go too much into details, but basically they foresee a process whereby, with sufficient trust, a simplified certification processes of products from the other side could be considered, but not mutual recognition, and that administrative arrangements could be in place between safety authorities on the EU and the UK side to facilitate the acceptance of EU and UK products. The most important point, perhaps, on the slides is really the part on the contingency measures in case of no deal, which is the first time in my mind that they actually talk publicly about what would happen for aviation in the event of no deal. And they say that ensuring basic connectivity will be very important, and therefore there are two options that could be considered: either a bare bones EU-UK agreement that would cover traffic rights and safety issues, or potentially an EU set of unilateral measures, hopefully complemented by the same thing from the UK side. So they tend to imply that in the event of no deal, they are not going to strand planes, but they'd like to come to some kind of agreement, or if not, decide unilaterally, probably, to allow planes to fly. Now, obviously, we haven't received the comments, that came with the slides, so it's hard to tell whether there are any restrictions attached to that, but it sounds, in any case, fairly reassuring. So one big issue that we have is, of course, that, well, road transport, road haulage, is in a similar situation. There is no free market in international road haulage by default. So anytime you do have liberalization of international haulage, it requires some agreements to be in place. So under no deal, there would be very severe limits on the number of international journeys that would be permitted, because the only default option is a system called ECMT permits. You could also consider bilateral permits, but again, extremely restricted. The ECMT system only covers about 3% of the needs. And that's assuming that all existing ECMT permits could be allocated to transport between the EU and the UK, which is not a given. And by the way, only 5 to 8% of the ECMT quota is unused at the moment, so it doesn't leave a lot of room. And this is not a solution, obviously. We also know that there is no certainty that qualifications are going to be recognized, for instance, driver CPC. So obviously all of these points are fairly worrying for road haulage. So we are going to keep making the case that road haulage would face similar issues as aviation. Sadly, it's not been prioritized so far in the same way as aviation in the negotiations, but we are going to seek reassurance that a similar process needs to happen as well for road haulage. And we've already started talking to the task force of Barnier, as well as to the Commission services about this a few weeks back, and obviously will intensify pressure during the year, also on the UK government, because this is a very, very important issue. So now going to the transitional period. So in terms of the transitional period, as I said, draft guidelines are in the process of being reviewed at the moment by the 27 member states staying in the EU. A first draft of these guidelines was produced by the task force of Michel Barnier on the 20th of December, and they are now going back and forth between the member states and the task force. And the intention is for a final version of these guidelines, which is basically going to set the EU negotiating position when it comes to transitional arrangements at the end of January. What the transition guidelines say at the moment is that a transition period could be considered by the EU, but only until the end of December 2020. The reason for that, and you will notice that the period is shorter than what the UK government had offered. The UK government was talking about 2 years, meaning end of March 2021. The reason for that is that the existing EU budget will run until the end of 2020. So because the budget is a 7-year exercise, and the UK will only contribute to the existing one, to the ongoing one, not to the future one in principle, the starting position for the EU, or at least the task force, is that the transition should end in December 2020. But this is not yet decided, so there's still a possibility it could change and that more time could be allocated. However, this transition would come with a number of restrictions. The first one is that work will need to be completed on all the withdrawal issues, including those not yet addressed in phase one, such as IP rights, data protection rules for data obtained pre-Brexit, customs matters for goods that would be in transit at the point of Brexit, or for instance, ongoing public procurement procedures, and that all of this will need to be translated into a legally binding document, essentially. So getting the commitment that this is going to be done is the first requirement for a transition to happen for the EU side. One of the priority conditions for the EU is also that freedom of movement remains protected for the duration of the transition period. So the deal on EU and UK citizens' rights that I presented earlier would therefore start applying as of the end of the transition period, because essentially for the EU, nothing should change during the transition when it comes to freedom of movement of people. The EU27 is very worried about potential regulatory dumping from the UK. So one of the conditions that they are highly likely to set in the final version of the guidelines is that the EU acquis, which is the body of law, which is agreed at EU level, will have to apply during the transition period and to retain its precedence over UK law. What does that mean? Well, because through the withdrawal bill, the UK government has anyway expressed the intention to, in a sense, copy and paste all EU legislation into UK law, that shouldn't actually mean much in itself. But politically, of course, it has a huge symbolism to it, because technically the UK would otherwise be free to change rules and regulations after Brexit. Well, this is going to be unlikely if a transition period is agreed, because it's something that the EU side is really keen on. The interesting thing is that any new rules as well that would be discussed and agreed during the transition period would have to be integrated into UK law. This is not something that has been agreed yet, but it's something that the EU side is likely to insist on. And importantly, the UK would no longer be able to participate in any bodies that would be set up to negotiate these rules after the withdrawal date, so after Brexit date, whether or not there is a transition. The UK should remain bound by all agreements that the EU has signed on its behalf or together with the UK, and most importantly by all the obligations stemming from these agreements. But however, the UK would no longer be able to participate in any of the bodies set up by these agreements. In terms of the single market and customs union membership, continued participation for the duration of the transition period is highly likely to be a prerequisite of the EU. It's certainly in the draft guidelines at the moment, and the EU is highly likely to insist on the need for the UK to comply with EU trade policy in full during the transition. They've also clarified so far, and it's likely to remain in the final version, that UK customs authorities would have to continue to collect EU customs duties and to perform all the checks required under EU law on goods coming from the rest of the world. The UK could also need the EU's authorization for any UK third-party deals or trade agreements to enter into force during the transition period. So, for instance, if the UK managed to negotiate free trade agreements with Australia, for instance, or Canada, or other countries during the transition period, and wanted to start enforcing them before the end of the transition period, that is likely to require EU's prior approval. The EU agencies will retain their competence in the UK, but the UK would no longer be represented in the EU institutions or able to take part in the decision-making process within EU agencies. Attendance at expert group meetings would likely only be on a case-by-case basis for UK officials with no voting rights. And whether the UK could still benefit from EU trade deals with the rest of the world has not been fully decided yet. So in terms of the obligations, the UK would not be able to unilaterally decide to, for instance, stop all controls or slash tariffs with third countries. It will have to respect the conditions set at EU level in terms of the trade policy. But if, for instance, the EU has signed an agreement, for instance, with Canada or Korea, the UK will have to accept goods from Canada and Korea under the same principle and requirements as it does today. So when the agreements say there are no tariffs on this or that good, the UK will not be able to charge tariffs on this or that good. It's not entirely clear whether, for instance, Canadian authorities or Korean authorities would be bound by the agreements when it comes to UK products. So this is really the thing that needs to be clarified. So in terms of what to expect and when in the future, it's the beginning of the year, so it's a good time to look back at the process and try and see where the big milestones are to be expected. A political agreement on the withdrawal agreement was reached in December last year. It's technically legally non-binding, but it's politically binding. So unless we end up in a no-deal scenario, it's very likely to apply. So this is going to get finalized during the first few months of this year, and the intention is to then end up with a legally binding withdrawal agreement and a political agreement on the framework for the future relationship in time for Brexit, so before March 2019. We're expecting that all of these agreements would be available in a final form, but non-ratified yet, as of October of this year, maybe November. And the remaining few months between October, November of this year and March 2019, which is going to be Brexit date, would be devoted to the ratification process, because it requires, of course, the approval from the European Parliament, the UK Parliament, as well as the Council at EU level and the UK government. There could then be a transitional / implementation period. At the moment, we're not entirely sure how long it will last, because as I explained, while the UK government wants it to last 2 years, so far the position at EU level is less than 2 years. It's only until the end of December 2020. And after that, hopefully there would be a new comprehensive UK-EU free trade agreement with related arrangements, for instance, for transport, that would be agreed. And the date of when that will start applying, of course, very much depends on whether there is a transition period and how long it lasts. So in terms of what you can do and how you can plan for Brexit and what to expect in the future. So we've tried to map out two fairly extreme scenario, I guess, a very pessimistic one and a fairly optimistic one. The truth might well be in between, but at least that will hopefully give you some perspective on what to expect and how to plan. So under the pessimistic scenario, for some reason, the negotiations would come to an end or stall, and there would not be any agreement. So this is very much the no-deal scenario. It's not obviously what either side want, but it could happen. So this is not something we should discard at this point. Under this scenario, Brexit would happen at midnight on 30th of March 2019. That's 11 p.m. 29th of March UK time. And then, of course, trades between the UK and the EU would be conducted under WTO rules, meaning that tariffs, customs duties would start applying, meaning that all the requirements, procedures, and processes that currently apply to trade with third countries when there is no preferential agreement, which actually doesn't happen as often as you might think, because even the US and China have some kind of facilitation mechanisms in place, for instance, for the recognition of the AEO status. All of these procedures, requirements, and so on would start applying as well. So you could expect the end of mutual recognition of conformity standards and certifications, border checks, both for customs purposes as well as, for instance, sanitary purposes. And all of this could create delays at the borders. A big question mark under this scenario is the level of preparedness of authorities, especially, but not only, on the EU27 side, because there would be very little time to prepare. It would happen in basically a year and a couple of months now, and there could be possible restrictions on transport. So now, hopefully, based on what the EU slides were saying, these restrictions shouldn't be too bad for aviation, but for road transport, we haven't seen any such statement or slides or anything from the EU that would say that they would be willing to come to sort of very last-minute agreement. Therefore, the assumption is that under a no-deal scenario, there would be restrictions for road transport. The positive scenario is that you'd have an agreement on the transition, hopefully by the end of the first quarter of this year. Hopefully you'd have an outline trade deal or something that obviously is not going to be equivalent to a trade deal, but would be a political document as detailed as possible by March 2019, all adopted, agreed, and ratified. And then at the point of Brexit, a 2-year transition would start that would basically preserve the status quo. And that a new UK-EU trade deal and future arrangements would start to kick in as soon as this transition period is finished, i.e. 30th of March 2021. So these two scenarios, as I said, are likely to be quite extreme. It's likely to be something in between, but at least it gives you something to plan for and to expect. So in terms of what happens until now, well, it's very important that you understand that essentially, at the moment, there are 0 changes until we leave. So the UK is still very much a member of the EU. We might talk about Brexit a lot, the press might talk about Brexit a lot, but it has not happened yet. All the same rules, all the same penalties still apply. And until Brexit, meaning until 30th of March 2019 midnight CET, or until the end of any transition period, if one is agreed, nothing changes. So now is really the time to assess the impact of Brexit on your operations and to prepare contingency plans. In terms of what you can actually do, we recommend that you start conducting an internal impact assessment if you haven't done so already, because the best way of planning is to know how you're going to be affected in the first place. We would recommend that you assess the impact of the worst case scenario of a no-deal option. Why? Because, well, this is possibly the clearest picture and the easiest to plan for. You don't have to enact any of these contingency plans at the moment, but it's useful to see what the worst case scenario would mean for you in terms of impact, so that you're not surprised should it come to that, which hopefully won't be the case. We recommend that you look at the impact of Brexit on your production and your supply chain, on your market more generally, so you need to know where your customers are, obviously, and talk to them. It's very important that you integrate the human resources implications. Hopefully, what I told you about the deal that was reached in December is going to help you in how you address the human resources issues. Yes, it's not legally binding. However, unless we end up with a no-deal scenario, it's highly likely that all of these protections are going to be in place. You need to look at the tax implications and implications in terms of VAT, for instance, for your companies, the regulatory implications, and for that you can look at some of the guidance notes that have been published by the EU. Various agencies have produced some notes, for instance, on pharmaceuticals or chemicals. And I understand that the UK government is starting to do the same. So the UK pharmaceutical body, for instance, as MHRA has already started to produce a similar note as well. You need to consider, especially if you have fresh produce or products that could be subject to sanitary checks, whether or not this is the case, what's the route you use, if you have any products of animal origin or plant origin as part of your products. You need to assess the impact on your transport providers as well, bearing in mind what I explained about road transport. We're going to try and make sure this is sorted out, but it's important to bear it in mind nonetheless, because you need to be aware of what the implications of no deal could be. And you need to assess the impact on your transportation choices. And obviously, if there are any opportunities, it's a very good idea to try and map these out as well, so that you can make the most of them. So in a more detailed way, some ideas to consider. We recommend that you factor in the Brexit impact when you review contracts with your suppliers, and when you look at your possible sourcing options. And by the way, the impact could be wider than just UK-EU, because obviously Brexit will have implications in terms of the trade deals with third countries. We recommend that you consider EU accreditation if you haven't done so. Being recognized as an authorized economic operator could actually allow you to reduce the frequency of checks, for instance. It's essentially the equivalence of a trusted trader scheme, and it comes with some benefits that could be quite substantial in the context of Brexit. We recommend that you assess your training and recruitment needs, especially from a customs perspective, because just the very fact that you'll have to deal with an additional number of declarations, for instance, for your products. There might be some products or markets where you've never had to do that sort of things, where you might need to do that. And if you're not doing it yourself, if you use third parties to do so, we recommend that you start talking to them about how you could make an increased use of their services in the future, what's their capabilities there, but first try and review your needs internally, obviously. And last but not least, you can also look at stock management whenever possible. This is clearly not going to be possible for all products. Perishable products are unlikely to be able to rely on that. But when it's possible, it might be useful, especially for the first few weeks after Brexit, and especially in the event of a fairly messy no-deal scenario. So for instance, one thing you could do is try and see whether there are any opportunities in terms of additional warehousing capabilities, or if you could, find somewhere to stock more goods in the future. It might be a good idea to try and see what the options could be in case you have to enact contingency plans fairly quickly in the coming months. So all of these are just recommendations on how to prepare for the worst case scenario. It's up to you, obviously, whether you decide to do it or not, but at least if you consider the impact of all of this on your business and you map out this impact and start thinking about potential solutions, you will be in a better place should it come to that. What can you do externally? Well, obviously, you can stay tuned. You can follow all the developments and so on through these webinars. You can voice your concerns with the UK government and your local MPs. Also, if you are a business that's based in other countries, or if you have colleagues from different units of your business based in other countries, it's a very good idea if you or they liaise with their other national governments, their MPs and regional authorities in these countries. Obviously, it's important to voice your concerns towards FTA and any other trade bodies you might be part of. It's important that you highlight the practical impact of political decisions when you talk to them, and obviously that you work with us on concrete solutions, because there's very little time left before we actually come to Brexit. So in terms of the forthcoming FTA events and activities, you might have received already the new Brexit Digest that we publish on a weekly basis. These are issued on a Monday afternoon, typically every week. We stop for 2 weeks over Christmas, and we will probably stop over August this summer, but the rest of the year we produce them on a weekly basis. If you are not receiving them and would like to receive that, at the moment it's free. You just need to email me and I can add you obviously to the list. The next webinar is going to take place on the 15th of February, same time, so that's 11:30 UK time, 12:30 CET time. On the 7th of March 2018, we will organize an FTA event on Brexit in Brussels in the European Parliament. This is still work in progress, but obviously if it's of interest to you, please feel free to contact me again for more information. And the last thing I wanted to highlight is the FTA Brexit seminar at Multimodal on the 2nd of May 2018. So if you are attending Multimodal, please make sure not to miss it and to attend it. It should be interesting, and we will have much more information by then that we'll be able to share with you. So with this, I am very happy to thank you for your attention and for following this webinar. If you have any questions, obviously I'll be happy to answer them. I can also take them and then answer them separately afterwards. Please mark the date of the next webinar in your diaries. That's the 15th of February. You can see the full list of dates for the webinars in the Brexit section of the website, and you will also find all our material on Brexit in there. So thank you very much again for your attention. I see that we have a question. When will the next Commission meeting on aviation take place, and what is the likelihood of an aviation deal being secured by the EU and the UK outside the framework of the Brexit trade talks? So I'm not sure, unfortunately, of when the next meeting will take place, because these are very informal workshops. So the list of dates and so on is not even public. Of course, the press hears about them, and they've decided to publish the slides because the press was talking about it. But these are very much internal meetings to prepare the EU27 position, and they don't want the UK government to be aware of what's being discussed, usually. It's interesting that it is decided to release these slides, in fact. So we're not sure, but obviously we're going to try and inquire, and if we manage to get hold of the answer, we will let you know. And what's the likelihood of an aviation deal being secured outside the framework of Brexit trade talks? I would say that it's probably higher than the likelihood of other sectors or topics being tackled separately, because aviation has been identified as a priority and as a bit of a separate thing pretty much from the beginning. So this is potentially something that is more likely than other topics, in my view, to be tackled separately. What about maritime shipping? We have another question on that. Well, for shipping, as you know, international shipping movements have been liberalized for a lot longer than the EU existence, so they should not be affected. Obviously, cabotage is a different matter. So the right to perform domestic operations for a third country operator is a different matter, and that's something that would have to be negotiated. I understand. As far as I understand, the only topic transport related that has been discussed so far as part of these preparations is aviation. They haven't had any specific workshops on maritime or on road transport. And just a point about maritime transport again, obviously you have different types of maritime transport. And if you look at RoRo, so when you transport the whole of the truck and the driver as well, it doesn't just have to, this is not just related to the framework for maritime transport, it's also related very much to the regulatory framework for road transport. So if you don't have an agreement allowing trucks to cross the border, that's obviously a threat to the RoRo model. But based on the goodwill that they have shown with aviation, I'm now slightly more optimistic about the likelihood of something positive coming out of the road transport discussions as well. Okay, so thank you very much for your questions. And if there are any other ones I haven't seen, obviously we'll answer them after the webinar. Thank you very much for your time and your attention again. And have a nice day. I'm now going to close the